Hi everybody, you're very welcome back to Law Hero. My name is Jen and I make videos about the law, and today we're talking about the FE1 Equity. And this paper is, again, fairly standard, and there's a few things you have to know. We're going to go down through the March and October 2024 papers, and these are my tips for 2025. So the first thing is the high frequency areas, I call them, like trusts, remedies, proprietary estoppel, undue influence. You are going to get those four without a shadow of a doubt in some shape or form. Trusts, I would bet my bottom dollar that charitable trusts are asked. They're just asked every single time in a question on their own, and yeah, so that's one type of trust. Then you may or may not have a problem question around constructive trusts, very popular from the point of view of the examiner, and then you would always get a question around express or resulting trusts and this, the subject matter, the three certainties. Then the next one is any type of equitable remedy. So when I say that, I talk about injunctions, specific performance, or tracing. They're all in my ebook. And the last area is definitely proprietary estoppel and undue influence. That's it in a nutshell. I mentioned the three certainties: intention, subject matter, objects for creating a valid trust. Be ready to apply cases like Hunter Moss v London Wine. When it comes to proprietary estoppel, the usual, be able to talk about Thorner v Major, Taylor Fashions, Gillette v Holt, all the Irish jurisprudence, and unconscionability as well. Trust, Vandervelde v IRC, re Abbott, Rio Saba, those kind of ones. And then constructive trust, Stack v Doden, Jones v Kernot, and new form model trust is very, very important. The examiner has alluded to it a lot. So be able also to apply remedies strategically. So for injunctions, there's a lot of different types of injunctions, but be able to apply the tests for each injunction. And if you're asked about an injunction and you're asked about a specific limb of a test, don't speak generally about the injunction. That's happened many times and you may fail the actual exam question. Specific performance, it's not really been asked every year, it's been here or there, so I would have that as a kind of backup one. And the same for tracing as well, it's not been asked every year, have it as a backup. Same with trustee duties, it hasn't been asked every year, but it's been asked very frequently, around the standard of care of fiduciary duties. And then I would say as well, just when it comes to how equity it works in tandem with other areas of law. So for example, leases, that's quite important. So Walsh v Lonsdale. So then when it comes to what came up in March 2024, so the first one was a problem question around charitable trust, and the examiner basically said that some people went straight into the CPRE issue without first considering whether or not the gift was charitable. And I actually always say that when I teach equity, it's like you have to first establish the charitable nature, because obviously if a trust is charitable, it comes with it a whole lot of tax benefits. Like there's a lot of benefits to it being a charitable trust. So the bar is high and you have to establish it first. The second question then, A or B. The first one was full and frank disclosure in the context of Mariva injunctions. And this is what I was talking about when I was saying that you don't talk about Mariva injunctions in general, you speak about the specific limb that the examiner is looking for. So here, full and frank disclosure. Obviously, again, this is a blanket requirement, a bit like uberrima fides in insurance contracts. What is the jurisprudence? Why have the courts asked for that, and why is it difficult? And then 2B, related to mandatory interlocutory injunctions. So actually, interestingly enough, the examiner made a point here and say it seems to be occurring increasingly frequently in recent sittings. More and more students are struggling to answer 5 questions, which is interesting. And so it may be that they are only preparing a limited number of topics which they bank on being on the paper, and or they only prepare certain aspects of the topic that they choose to study, and so are unable to write an adequate answer when the topic banked upon does not appear, and or a different aspect of the issue that they have studied appear in the examination paper. So it's this inability to pivot, it's this inability to answer the question because you've just no knowledge on the topic. That is an absolute no-no at FE1 level. And it is difficult to find the balance between a massive curriculum and utilising your time so that you can be efficient when studying for the exam. But as I said at the start of this video, there are 8 or 9 topics that are always asked. So just have 8 or 9 topics rather than focusing on 5. It's just not a good strategy. Anyway, the third question was a problem question around a presumed resulting trust and the presumption of advancement. There's a lot of case law around that. The fourth question was, I think, an essay question around the unconscionability limb that has crept into estoppel. The fifth was a problem question around tracing. The sixth was an essay question, I think it was a notes question. The seventh was a problem question around the 3 certainties. And then the 8th was an essay question. Now this comes up every single year, and it's a particular bugbear of the examiner, which is the case law that people are studying for this question around obligations of a bank when one family member guarantees a business loan for another member or of his or her family. So they're acting as guarantor, something which happens a lot in families. Is the bank required to take appropriate steps to ensure that the family member acting as guarantor has received independent legal advice prior to the execution of the guarantee? Given the amount of attention this issue has been given in recent Irish case law, the question specifically asked students to consider from Fitzgerald onwards. Nonetheless, many of the students who attempted this question started with case law handed down many years before Fitzgerald, when some of those appeared unaware of the developments in this jurisdiction in recent years. So again, the examiner says you should consider at least Fitzgerald, Roach v. Budimer, McKellen, Curran, De Crester, Sheen and Connolly. Those are all in my ebook. I've covered them all. And yeah, like I think if you're throwing in case law for the sake of case law, you're probably desperate and you're not going to pass anyway. Like, it's this old kind of, throw everything at the examiner and hope that something will stick. That's a very like leaving cert mentality. It's not real world way of thinking, and it's not going to pass you the exam. Like real life, people aren't going to award you for effort. They're going to award you for accuracy. So in October then, there was, the first question was a problem question around obtaining rectification and the counterclaim for specific performance. So these are your equitable remedies that I discussed. The second question then is a essay question about tracing. You can see there, so tracing has come up twice in a row now, and like the examiner seems to be focusing more on equitable remedies, which is interesting. The third one then relates to trust and the validity of the trusts. There's 2 there. They seem to be charitable, because I see the words environmental and religious brotherhood, so I'm guessing they're charitable trusts. Question 4 then, I see Merck, Sharp and Dome, so the only thing I can think of is Campus Oil. So prohibitory, interlocutory, injunction, and that's an essay. Question 5 then seems to be like a secret trust, maybe, just from looking at it. Question 6 is an essay question talking about Reeve Arco Limited, which is Irish Court's new model constructive trust. And then question 7 was a notes question. I'm not really into those notes questions, to be honest. I think I would only do it if I was really stuck, just because I like to have a problem question to grapple with. And then question 8 then is around loan repayments, defaulting on loan repayments, and the bank wishes to enforce the charge. So yeah, this looks like to be getting legal advice legal advice and undue influence. So yeah, I agree with the examiner. Don't leave yourself short. Cover at least 8 topics and you'll be fine. I'm going to see you in the next one for property. But yeah, all my notes are available on lawhero.eu.